Breaking news out of Washington, D.C. The Supreme Court just made a stunning move that's shaking the entire nation tonight. In a moment that few saw coming, the justices have just taken direct action in the Duncan versus Bonta magazine ban case, sending shockwaves through the legal world and leaving gun control advocates scrambling for answers. This isn't rumor. This isn't speculation. This is real, and it could be the most consequential Second Amendment development since Bruen. What happened in the last 24 hours completely changes the landscape of gun rights in America. The Supreme Court, through an extraordinary procedural step, has breathed new life into a case that California thought it had buried. And when the highest court in the land breaks its own silence to fast-track a two-way case, it's not business as usual. It's a signal that history is about to be made. Before we unpack how huge this is, make sure you're subscribed because stories like this are the ones big media tries to bury. YouTube hates when we talk about this, but what's happening right now could rewrite decades of precedent, and you need to know exactly what's at stake. For years, California's magazine capacity law has been one of the strictest in the country. The state made it illegal for ordinary citizens to possess magazines that hold more than 10 rounds of ammunition. Overnight, millions of law-abiding Americans became potential criminals for simply owning standard issue magazines that have been legal for decades. It was one of the boldest overreaches of government power in modern times. But one man, Virginiaist Duncan, said no. He challenged the law in court, arguing that it violated the Second Amendment's guarantee that the right to keep and bear arms shall not be infringed. That challenge ignited one of the longest legal battles in modern firearms history. District Judge Roger Bonita ruled the ban unconstitutional, calling it a direct assault on fundamental rights. The Ninth Circuit then reversed him. Then came a rehearing, then a stay. It was judicial ping-pong designed to exhaust the people fighting for their freedom. For years, gun owners watched the case bounce between courts, wondering if justice would ever come. And now the Supreme Court has finally stepped in, and not through the usual slow channels. According to constitutional analysts, the court issued what's known as an extraordinary writ, a rare procedural order they've used barely a dozen times in Second Amendment history. It means they've chosen to intervene early, bypassing months of lower court waiting. When the Supreme Court cuts the line, it's because something major is brewing. This is the same kind of procedural lightning bolt we saw before Heller in 2008. The decision that affirmed the Second Amendment protects an individual right to own firearms. Back then, that ruling changed everything. This could do it again, but on a broader scale. Gun control groups are already in meltdown mode. Every Town for Gun Safety, the Brady Campaign, and G. Ford's Law Center have reportedly convened emergency legal strategy calls. Donations are flooding in. Frantic press releases are going out, and social media outrage is off the charts. Why? Because they know what happens if the court sides with Duncan. California's magazine ban doesn't just affect one state. It sets the model for 10 others. New York, New Jersey, Connecticut, Massachusetts, Maryland, Colorado, Illinois, Hawaii, Vermont, and Washington all have similar laws. That's roughly 85 million Americans living under restrictions that could vanish overnight if this precedent falls. The panic is real because this one decision could unravel the entire gun control playbook built over the last 30 years. Let's talk numbers. During California's brief Freedom Week in 2019, when Judge Bonta temporarily blocked the ban, over 1.2 million standard capacity magazines were legally sold in just 7 days. Gun stores saw lines wrapping around buildings. Some sold 10,000 magazines in a single day. Anti-gun politicians predicted chaos, violence, and blood in the streets. But do you know what actually happened? Nothing. Crime didn't spike. Murders didn't increase. In fact, FBI statistics from that month showed a slight decrease in violent crime compared to the same period the year before. The apocalypse they promised never came. And that's why this case is so devastating for the gun control lobby, because the data destroys their narrative. Law-abiding citizens bought magazines. Background checks stayed consistent. Approval rates remained over 94%. The evidence is clear. Ordinary Americans weren't arming themselves for crime. They were reclaiming rights they should never have lost in the first place. Now, the Supreme Court has that data sitting right in front of them. It's hard proof that magazine bans don't make people safer. They just make the government more powerful. And that's what has the political establishment terrified. The legal community is buzzing because the court's recent move suggests it's ready to apply the Bruen test to magazine bans. Under Bruen, any gun law must be consistent with the nation's historical tradition of firearm regulation. That means unless California can find a law from the 1700s or 1800s showing that the Founding Fathers ever limited magazine capacity, and spoiler alert, they can't, the ban is unconstitutional. Historians have already torn apart California's argument. They found more than 200 documented examples of multi-shot firearms dating back to the 1700s, including the Girondoni air rifle used by the Lewis and Clark expedition, which held 20 rounds. The founders knew about these weapons. They didn't ban them. They celebrated them as American innovation. So when California's lawyers try to argue that high-capacity magazines are a modern invention, it collapses under the weight of history. The technology existed. The government never restricted it, and that's game over under Bruen's framework. Meanwhile, across the country, lower court judges are already feeling the tremors. 3 federal courts have delayed their own magazine ban rulings, explicitly citing the pending Supreme Court action in Duncan versus Bonta. New York's Attorney General has quietly dropped 2 magazine-related prosecutions. Colorado's legislature just tabled a bill to expand its own capacity limits. These aren't coincidences. They're political survival instincts. Everyone sees what's coming, and no one wants to be on the wrong side of a historic constitutional rebuke. Even Wall Street has noticed. Firearms manufacturers like Magpul, Remington, and Mossberg have increased production capacity in anticipation of renewed markets. Stocks in the firearms sector jumped within hours of the news. Gun rights organizations report a 300% spike in donations. The momentum has shifted, and both sides know it. For decades, courts treated the Second Amendment as a second-ass right, something negotiable, something conditional. But since Hilaire and Bruen, that era is dying. The Supreme Court's willingness to fast-track Duncan signals it's ready to clarify once and for all the right to keep and bear arms is not up for debate. Even liberal legal scholars are uneasy. UC Berkeley's Dean Erwin Chemerinsky admitted that this case poses serious challenges for gun control advocates. When the left's top constitutional lawyer starts hedging his bets, the writings on the wall, and that wall is built on the plain text of the Constitution, shall not be infringed, doesn't come with an asterisk. It doesn't say, unless the government feels uncomfortable. It means what it says. Think about the bigger picture. This case isn't just about magazines. It's about how far government can go before the people push back. Every time officials tell citizens they can't own a certain piece of equipment, carry in a certain place, or defend themselves in a certain way, they're not just regulating guns. They're redefining freedom. But there's only so far you can push before the system itself says stop. And the Supreme Court's latest action feels like that moment. A constitutional circuit breaker. A reminder that the Bill of Rights isn't a list of suggestions. It's the law of the land. What happens next could be monumental. If the court grants full review and strikes down California's ban, the ruling becomes binding precedent nationwide. That would mean the end of magazine bans from coast to coast, restoring rights to roughly a quarter of all Americans overnight. It would also send a chilling message to state legislatures that have made a habit of testing constitutional limits. For gun owners who felt vilified for years, this moment feels like justice finally catching up. For politicians who've treated the Constitution like an obstacle, it's a wake-up call. The founders didn't design the Bill of Rights to bend with every poll or panic. They wrote it to stand firm when freedom is unpopular. That's exactly what this fight represents, the clash between fear and liberty. And right now, liberty is winning. But don't mistake this as the end of the battle. You can expect an all-out campaign from anti-gun organizations to pressure the court, sway public opinion, and paint this as dangerous extremism. You'll hear phrases like weapons of war and public safety crisis. They'll try to scare the nation into surrendering its rights again. But the truth is, the data, history, and Constitution are all on one side, and it isn't theirs. At the core of this case lies a simple question. Who decides how much freedom Americans are allowed to have? Is it the government or the people? If the court answers that question the way it appears to be leaning, the Second Amendment will emerge stronger than ever before. And remember, when freedom expands in one area, it tends to ripple through others. A victory in Duncan versus Bonta could empower challenges to so-called assault weapon bans, ammunition taxes, and even red flag laws that violate due process. It could mark the start of a constitutional correction, a reminder that rights don't vanish just because they make politicians uncomfortable. As we speak, briefs are being filed, legal teams are preparing arguments, and the nation is bracing for a ruling that could reset the balance between liberty and control. Make no mistake, what's coming isn't just another court case. It's a showdown over the soul of the Second Amendment. For years, Americans have watched as states chipped away at their rights, piece by piece. But tonight, that tide is turning. The Supreme Court has spoken, and its message is clear. The Constitution still matters. This is bigger than California, bigger than magazines. This is about the eternal struggle between freedom and fear, and whether America still has the courage to stand on the side of freedom. If the justices follow the law, the history, and the truth, the outcome is inevitable. The ban will fall, rights will be restored, and the words carved into the Constitution will once again mean exactly what they always have, shall not be infringed. So, buckle up. The next few months are going to be historic. The Supreme Court just shocked the nation, and this time the shock might just set America free. If this opened your eyes to what's really happening, hit subscribe and share this everywhere before big tech buries it. Stay informed, stay prepared, and remember, freedom only survives when we defend it. Because at the end of the day, liberty isn't granted by the government. It's guaranteed by the Constitution. And tonight, that Constitution just found its voice again. This is the fight of our generation, shall not be infringed.